Why would you allow the state to determine who will care for your minor children if you have minor children when you die? Why would you allow the state to determine to whom and how your assets are to be distributed when you die? Well, that's exactly what will happen here in the state of California if you die intestate. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. What does it mean to die intestate? It means that a person died without leaving a last will and testament, and the transfer of that person's estate will likely need a probate procedure. When someone dies intestate, their assets are distributed according to the laws of intestate succession, which is also known as a state will. So in other words, when you don't leave a will, the state has one prepared for you. The state will also determine who will be the administrator of your estate. Here is what typically will happen if you or someone you know die intestate here in the state of California. If someone were married and their parents predeceased them and they had no children and no brothers and sisters, their spouse will receive the entire estate. If someone were not married but had children, their estate will be divided equally among their children. California state law defines children as blood or adopted descendants. A stepchild or a foster child is not entitled to part of an estate. When someone is married with no children, however, their parents are still living, the spouse will receive 100% of the community property purchased during matrimony, and half of the personal property that is movable. The living parents will receive the other half of the personal property. If someone were married and had one child, the spouse will receive or inherit all of the community property and one half of the personal property, and the one child will inherit the other half of the personal property. If someone is married and had multiple children, the spouse will inherit all of the community property and 1/3 of the personal property. The other 2/3 of the personal property will be divided equally among the children. Question of the day: were you aware of the California intestate succession laws prior to seeing this video? Let us know in the comments below. Some assets will not require a probate procedure in order to transfer them. These assets are transferred by operation of law. Also, assets that are properly funded in a living trust or placed in a living trust will not require a probate procedure to transfer them. I'm Daryl Williams. This is Win-Win Realtors TV. If you've gotten value from this video, be sure to like, share, and subscribe. If you have any questions for me, my contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need an estate planning or a probate attorney here in the Southern California area, feel free to contact me for a referral.